Talking about the United States Supreme Court and what they do. And we're going to be looking at the jurisdiction, in what jobs does the United States Supreme Court have, in what realms do they make decisions, who are these people, and how do they get these jobs. So first off, it is the job of the United States Supreme Court to look into any action of the president or any law that Congress passes to determine whether or not it is constitutional. Areas in which they have original jurisdiction, which original jurisdiction means areas in which they are the first people to hear these cases. Number one, cases involving diplomats from foreign countries. If a representative of Britain comes here and commits a murder, that case will be heard by the United States Supreme Court automatically. There's lots of neat movies about that. There are cases where that has happened in real life, and there's a ton of movies depicting what might happen. The other situation in which the Supreme Court is going to be the first to hear about this is if one state has a dispute with another state. And sadly, this has happened many times. The earliest case was McCulloch v. Maryland, where one state was trying to tell another state what to do. And the United States Supreme Court had to make a ruling and basically say, states don't have authority over other states. That's not how it works. That's the job of the federal government. And when the Supreme Court made that ruling, and they were the first to hear the case, then that ruling was final. Unless the Supreme Court decides to hear it again in a different way. So some other cases in which the Supreme Court is going to interact. More commonly, they're going to hear appeals from lower courts. And this is where you as an individual can actually change a policy, and you can do it through the court system. For example, in Escobedo v. Illinois, a man was convicted of stealing money from a jukebox. Now, he probably did it. The jukebox was busted, the change fell out, the man allegedly stole the money out of this jukebox. He was sentenced to a very long prison term. He couldn't afford a lawyer, he had no one to represent him, and so he went to jail. And he wrote a letter to the courts appealing his case because he didn't have a lawyer and the state didn't provide him with one. And because of that, in that case, now you have the right to an attorney even if you can't afford one, and a public defender is provided. That went to the Supreme Court. And also, the Supreme Court doesn't have to hear every case presented before it. And so there are lots of people in this country trying to get the Supreme Court to rule on various issues. And the Supreme Court just hasn't chosen to rule on those issues. Okay, so who are these people? There are 8 associate justices. There are 9 Supreme Court justices total. There are 8, and there is 1 Chief Justice. The first Chief Justice was a man named John Marshall, and he presided over the Supreme Court for more than 30 years. And his decisions were instrumental in shaping what the Supreme Court was all about. Now, it is the duty of these justices to hear and rule on various cases relating to constitutional matters. So, the next question is, how do we get these people? We've just learned that they are not elected through the democratic process. They don't have to care if you know who they are. They don't have to solicit your votes. The judicial system was developed to be a check on the political process, because occasionally people vote and make bad choices. And so there has to be a group that's above the fray to be able to stop the abuses of poor decisions by the majority. Okay, so occasionally a Supreme Court justice will retire. More commonly, they die in their position. And when one dies or retires, a vacancy is opened. And that vacancy has to be filled. And so it is the job of the President of the United States to appoint a new Supreme Court justice. This is an extremely important role of the President to pick members of the U.S. Supreme Court. And this is really the only way in which the court is political, because it is the job of the President, who has just ran for a political party and received the votes of the American people, and now has the authority to pick one of these justices. And that President is going to pick a justice which most closely aligns with his or her views. But that's not the end of the story. The Senate has to approve whoever it is that the President picks. And the Senate can confirm or deny the appointee. Or in the case of 2016, they are not allowed to technically refuse to hear a case, but now that's been done apparently. And finally, they can choose to reject a nominee. So next is, how did these guys get here? You know, what does the Constitution say about the requirements for a Chief Justice? Number one, most of them are lawyers. Most of them have been practicing law their entire lives. These guys have usually been practicing for over 30 years before they get to be Supreme Court Justice. Many of them go from law to become judges in lower courts. Most start out in district or magistrate courts and work their way up to the state or federal level. And some even come from other elected positions. For example, William Howard Taft did not win re-election as President of the United States in 1912, and he actually retired from becoming president and went to work in the Supreme Court. He's the only former president to have gone into the United States Supreme Court. The first African American Chief Justice was Thurgood Marshall, and he was appointed in 1967, and he was involved in a number of these landmark civil rights cases that you guys are learning about. The first female justice was Sandra Day O'Connor. She was appointed in 1981 by President Ronald Reagan. And so the next part is, what do these people do now that we know who they are? So they are the final court to hear a case, and their decision is final. So, number one, no law can be made without the Supreme Court's approval. They can overrule a law. The President cannot make a decision if the Supreme Court overrules it. And so, technically, the legislative and the executive branches both must abide by the rulings of the United States Supreme Court. What is their powers? Most importantly is judicial review. And judicial review is the power of the Supreme Court to say whether any federal, state, or local law or government action goes against the Constitution. They are the experts on the Constitution, and it is their job to ensure that our government is in compliance with the United States Constitution. And of course, that's where you hear the term constitutional, and we use that often in our class. And that means, is it in accordance with the Constitution? Like Tinker v. Des Moines, is that speech protected? And we use the Tinker standard because of that Supreme Court case. Just because the Constitution says free speech, unfortunately that is open for interpretation. but it is the job of the Supreme Court to interpret what that means. And their interpretation may change at a later date. Currently, it means as long as your speech is not hurting anyone or disruptive in nature. And the current United States Supreme Court, as we know it now, was established by the Judiciary Act of 1789. And one of the earliest and most important cases where they first looked into an action that the president had taken, and they actually told that president that he could not do that. It goes all the way back to the second president of the United States, John Adams, lost re-election to Thomas Jefferson. And on the last day of this member of the Federalist Party's office, well, it wasn't actually John Adams that lost. He had served his 2 terms, he was going to retire, and the Federalists were about to lose power. Thomas Jefferson, a Democratic Republican, was about to assume the office of president. And the Federalists tried to stack the courts to ensure that Jefferson could never get anything done. And the Supreme Court ruled on the matter and decided that John Adams was not allowed to do that. And so this was the first time that the Supreme Court ever told a president no, and they've been able to tell them no ever since. So what is judicial review? Well, number one, it's established on the principle that the United States Constitution is the supreme law of the land. It is our highest authority. And number two, if there is a specific conflict between any federal or state or local law and the Constitution is going to win out. And that's what judicial review means. So for example, if Henderson County tried to pass a law that was contrary to the United States Constitution, we would be found in violation and we would have to fix it. The judicial branch is the safeguard for the Constitution in our country. It is there to make sure that our government abides by the principles in which we established our nation. Obviously, the Constitution has changed over time, and that's where the amendments come in. And so the Supreme Court exists to ensure that those amendments are interpreted and enforced in a way that is in accordance with the writing of that document. And if it's poorly written, then it has to be fixed. The Supreme Court also has limits. First limit, and this is a tricky one. The Supreme Court is not an enforcement arm of our government. They're judges in robes. They're not police officers with guns. They don't represent the military. Our president represents the military. Our president represents all law enforcement in this country. And so there was a case, for example, when Andrew Jackson wanted to kick the Native Americans out of the Southeast with the passage of the Indian Removal Act, that the Supreme Court actually told him, no, you can't do that. It was the famous case of Worcester v. Georgia. The Supreme Court said, no, these people legally own this property. You cannot remove them from their property. Andrew Jackson said, and I quote, the court has made its ruling. Let's see if they can enforce it. Mwahaha. And he kicked him out anyway. Now, of course, this caught him a lot of flack, but he got away with it because now the Cherokee Nation resides in Oklahoma, with the exception of the Eastern Band in the community of Cherokee. So that's Worcester v. Georgia. But also, there have been disagreements between Congress and the United States Supreme Court, and there have been cases where, for example, when the U.S. Supreme Court ruled in Dred Scott versus Maryland that a slave was property and not a person, Congress responded a few years later, about a little over 10 years later, with the passage of the 13th Amendment. And so by adding to the Constitution, they overruled the Supreme Court. The Supreme Court is not all powerful. There are limits to their power. And yes, Congress has the authority to impeach or remove judges. Let's say that a judge goes haywire and makes decisions that are contrary to the Constitution. Dred Scott was a terrible decision. A slave is not property. They are a person. But at that time, it was in keeping with the Constitution. So the Constitution had to be changed. It wasn't the judges themselves. But if the judges themselves are found to be negligent in their duties, well then yeah, that could be grounds for removal. Next, they can only hear cases that come to them. Now there's plenty of people out there just waiting for their case to be heard by the United States Supreme Court, but it has to be brought to them first. And then finally, they can't rule on matters in Henderson County. They only deal with national issues. For example, the 2000 presidential election. It was between George W. Bush, who won, and Al Gore, who maybe you've never heard of. Well, here's what you need to know. Al Gore won the popular vote. Not only that, but the electoral vote was so close, it came down to the state of Florida. Florida's election results were called into question for a number of reasons. The paper ballots they were using were causing lots of problems. People weren't punching all the way through the hole they were supposed to. People weren't even voting properly. And so a manual recount was started. The manual recount was going to possibly overturn the results of the 2000 presidential election. Had the manual recount been allowed to continue, Al Gore would have been your president instead of George W. Bush. However, the United States Supreme Court intervened, ordered a cease and desist to the recount, and declared Bush the victor.